So for the record, this is the December 7th, 2016 formal hearing of the Utah Board of Oil, Gas, and Mining. And our first agenda item is docket number 2016-005, cause number 222-16, in the matter of HINTO Energy. We'll take appearances of counsel at this time.
Melissa Reynolds with the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Okay, seeing no one else, Melissa.
Thank you, Mr. Chairman, members of the board. As you all know, this matter against HINTO Energy Incorporated has been ongoing since the division filed its notice of agency action in January of 2016. But we have finally come to a resolution of the matter and developed a way to avoid any additional hearings on it. So today I will provide a brief background for the record. Then I will explain the motion to stay entry of judgment that the division filed with the board last night and move for the board's approval on that motion. Finally, if the board approves the motion, I will request the board to enter the proposed order that we filed along with the motion. As an initial matter, because the parties have agreed to enter into this motion to stay entry of judgment, I have represented to HINTO's counsel that he did not need to appear before you today. Now, by way of background, HINTO is the designated operator of 8 wells in Grand County, Utah. And in January 2016, due to HINTO's prolonged noncompliance, the division filed its notice of agency action with the board. Since then, HINTO has brought 2 of its 8 wells into compliance, and any order issued in this matter should not address those 2 wells. Since filing the notice of agency action, in an effort to work with HINTO, as you are all well aware, the division has agreed to numerous continuances. And in doing so, the division and HINTO entered into a stipulation for judgment or dismissal in March of 2016, which required HINTO to complete some work on some of its wells. But by October 24th of 2016, HINTO had completed some of that work, but had not yet complied with the full terms of the stipulation for judgment or dismissal. Specifically, they had not put the Sweetheart 7 well online, plugged the Sweetheart 5A well, or completed the surface work on the Little Boy 2, 1401, Sweetheart 2A, or Sweetheart 1402 wells. So given that failure, DAGM filed a motion for entry of judgment against HINTO, and on November 30th, we filed a proposed order on that motion for entry of judgment. However, after doing so, the division heard from HINTO, and HINTO asked what it could do to avoid entry of that judgment. Even though we had continued the matter numerous times, the division agreed to enter into the motion to stay entry of judgment, which is before you today. That motion has been signed by both parties and agreed to by both the division and HINTO Energy. By filing it, the parties move the board to do a few things. One, find that there are currently grounds to enter judgment against HINTO based on its failure to comply with the terms of the stipulation for judgment or dismissal. But 2, to withhold entry of that judgment for 60 days to give HINTO one last chance to complete the remaining work. 3, to order the division to file a motion to dismiss if HINTO completes the remaining work by February 7th, 2017. And finally, if HINTO fails to complete the work by the required deadline, order the division to file findings of fact, conclusions of law, and an order for the board's signature. According to the agreed upon terms in the motion for to stay entry of judgment, the order will forfeit the bonds for all 6 wells, in addition to a $15,000 amount that HINTO placed into escrow with their attorney as additional surety, for a total of $51,000. The order will also let the division use that full forfeited amount on any well that still requires work, without regard to the particular well to which each bond applies. That essentially summarizes the motion to stay entry of judgment that you have before you today. And if the board has any questions, I'm happy to answer them. And I also have Josh Payne and Dustin Doucette here to answer any questions that I am unable to answer.
Okay, we'll start with Carl.
Maybe this question's best put to Dustin. The work that they're needing to do in the next 60 days, will severe winter conditions potentially hamper that significantly where they can't do it, or will have difficulty doing it, in your opinion?
Yeah, I mean, out there, I guess if they get any moisture, it could be difficult to do the work out there, for sure. If it's frozen, a lot of times they can get out on that Mancos and not have any issues. So I know in February it usually gets a little bit worse weather-wise when things start thawing out and stuff like that out there. But yeah, I mean, they could have some issues getting some of the work done.
With that in mind, is there any reason to give them a little longer time till early spring, or are you comfortable with holding it at 60 days? It's kind of an operational question that has some imponderables, I realize, but
Yeah, I don't know if it would make too much difference. I mean, going a little bit longer. I mean, obviously, if there's weather issues that they couldn't get the work done, then we'd probably be getting an extension on that. I don't know if maybe Melissa can answer that as far as if it's a firm deadline, or if there's options for extending because of extenuating circumstances.
if we can establish some good faith efforts has been made at some point. Melissa, what?
Josh Payne with the division. On that, if like Dustin said, if we can basically have the option to extend it based on whether the division's willing to work with them, we were hesitant to allow just an open-ended extension due to whether, because in the past working with them, we've had a lot of excuses or things come up that have given them basically waiting until the last minute or till the deadline before they opt to do any work. And that's kind of where we came up with the February 7th deadline, to avoid any of that. Again, if we have that option open to extend it on our I guess decision or agreement, we're open to that for sure. We just didn't want to put that out there right up front.
Okay, thank you.
Other questions, board members? Yes.
Could you remind us how long you've been working with them to try and get this work accomplished?
Yes, so I came into the mix in January of 2016. That's when the division filed the notice of agency action seeking to forfeit the reclamation bonds for HINTO's wells. But I know that the division had compliance issues with them long before that, and maybe Josh or Dustin can speak to those because I didn't begin working with them until January of this year.
Yeah, I think HINTO took over the wells in I think February of 2014 timeframe, and we've kind of been working with them since that time to get all their wells in compliance. Now, since that time, they have done some things. They've plugged several wells. They've returned a couple to production, or have a couple on production, and they have done some cleanup that they've been asked on several of the sites as well, filling in pits, etc. So there's probably minimal amount of work to be done on several of those wells that have been plugged. Just the final reclamation, knocking down berms, stuff like that. So they have done stuff, but we've kind of hobbled along, I guess, is what we've done for probably the last 2+ years.
Thank you.
Mr. Brown, Mr. Moon, any questions? I've got a couple of just general comments and a compliment. We have, as a board, have asked the division to, I don't know if I'm going to say this right, but to more predictable process in terms of these extensions on extensions on extensions. And I think in what I'm saying is that you've listened to that, and the cases before us today seem to have a roadmap to the end. And so to the extent that you have a roadmap to the end, I believe that's in compliance with what the board has asked you to consider. And you're to be complimented, Mr. Alder. Thank you. You're part of that process, and the rest of the legal team. And that's kind of like would like to see more of that, I believe. And I know as other members on the board, if you want to talk about that, I think it's, you know, in the small mine area is where we've seen the most of it, but this is an oil and gas case. But I think that's kind of where we're hoping that you would go, and we're seeing more of that, and so we want to compliment you for that. Mr. Brown.
Does the remaining work require mobilization of equipment, or is it already on site?
It would require mobilization of equipment, specifically for the plugging of the wells.
Makes Carl's point a little bit more relevant, but I'm still inclined personally to hold them to 60 days.
Yeah, and I think the flip side, Rich, why don't you go ahead?
Oh, I was just going to say, you know, the risk that they're bearing on the 60 days is part of the. I mean, they'd have 2.5 years to do the work under good weather conditions and favorable times of year. After all, huh?
But I think the board has an aptitude or an attitude to kind of hold people's feet to the fire. If they say this is what we're going to do, I think you're going to see. I think that is the inclination of the board, if I'm reading everyone correctly. So with that, back to you, Melissa. Why don't you give us the course of action that you recommend?
Thank you, Mr. Chairman. The division would move the board to enter the proposed order approving the terms of the motion to stay entry of judgment, and we again provided that proposed order for your signature today.
Board members? The motion would be in order, or discussion, but the motion would be in order to approve council's for the division's request. Is anyone willing to make that motion?
I'll make that motion.
Thank you, Mr. Brown, and it's seconded by Carl. Any discussion of that? Seeing none, the motion before you is to approve the request of the division as to HINTO Energy to stay the matter. And I think I've said that right. All in favor say aye.
Aye.
Any opposed? Let the record show that that was unanimous. Thank you very much.
Thank you.
We are now down to agenda item number 2, docket number 2016-016, cause number 222-17, in the matter of PATMOS Energy, LLC. We'll take appearances of counsel.
Melissa Reynolds for the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Any other counsel? Seeing none, it's you, Melissa.
Thank you, Mr. Chairman, members of the board. This is a very similar matter to HINTO, so I will proceed with explaining what we have before you today in a similar fashion. As you know, the hearing on this matter has been continued numerous times in recognition of PATMOS's continued work toward bringing its 3 wells into compliance. And at this point, PATMOS has completed the work required by the stipulation that we entered into on September 27th, 2016. Specifically, they've plugged and restored 2 of their wells, and they've reclaimed a pit on their 3rd well. Recognizing that that work has been completed, the division and PATMOS entered into a stipulation for dismissal, which we filed with the board this morning. And again, because the parties have come to this agreement, I represented to Tom Crowther, PATMOS's attorney, that he did not need to appear before the board today. Now I will briefly explain the stipulation to dismiss and then open it to the board for any questions that you may have. In entering into this stipulation, the parties agree that this matter should be dismissed from the board's docket. I should note that we did not file a motion to dismiss or simply file a motion to dismiss because we wanted to address how to deal with some issues moving forward, particularly because PATMOS will maintain one of its wells, the CBM-1 well. So these issues relate to that particular well, which PATMOS will continue to operate, and the stipulation describes various requirements that relate to that well, which include maintaining a field presence by conducting monthly inspections of the well, a June 1st, 2017 deadline to provide some information required by Utah Administrative Code Rule 649-336. And because the well has been shut in for such a long period of time and remains shut in as of today, a December 7th, 2017 deadline to either put the well on production or plug it. So they have an entire year to take some action with respect to that well. The issues included in the stipulation to dismiss also relate to bonding for the CBM-1 well. Currently, we hold a $120,000 blanket bond for all 3 of PATMOS's wells. So the stipulation requires PATMOS to submit an estimate of the cost of plugging and restoring the 1 well that it will continue to operate.